She stepped onto my lawn with a clipboard and authority she didn't have, triggering an inspection that unraveled an HOA empire and exposed how fragile power becomes when law arrives. Let me start from the beginning. The neighborhood had always marketed itself as peaceful, manicured, and compliant. Perfect lawns, neutral paint palettes, and an unspoken understanding that the Homeowners Association existed as a quiet overseer rather than an occupying force. That illusion lasted until the morning the inspection happened without permission. The day began unremarkably, with routine academic work occupying my attention and the house existing as a background constant. Years spent teaching constitutional law had trained my mind to notice patterns, authority claims, and procedural irregularities even in mundane settings. That training activated the moment an unfamiliar figure crossed the boundary of my property with purpose rather than hesitation. The individual carried herself with the unmistakable posture of assumed authority. Her clothing, clipboard, and deliberate pacing signaled enforcement rather than neighborly curiosity. She bypassed the walkway and moved directly along the side of the house, examining fixtures, siding, and windows with practiced scrutiny. No notice had been given, no consent had been requested, no emergency justified the intrusion. Rather than interrupting, I observed. Documentation began immediately, not out of emotion, but out of habit. The same discipline applied in courtrooms and lecture halls now applied to my own front yard. Timestamps were recorded, movements were noted, the absence of posted notice or emergency conditions was confirmed. The inspection continued as if legality were optional, as if the mere existence of an HOA dissolved constitutional boundaries. The association's rules were familiar to me. Like many such organizations, they relied heavily on fine print, selective enforcement, and the assumption that residents would not challenge overreach. The governing documents, filed with the county and subordinate to state and federal law, did not grant warrantless inspection authority. They never had. Yet enforcement personalities often behaved as though they did. The inspector moved closer to the rear of the house, peering into spaces not visible from public view. This was not a drive-by compliance check. This was a search conducted by a private HOA actor without consent, notice, or lawful basis. The distinction mattered not only legally but symbolically. Still, there was no confrontation, no raised voices, no dramatic intervention. Viral HOA conflicts often thrived on emotional escalation, but this situation required none. The power imbalance favored patience. Every action was logged. Photographs were taken from inside the home, documenting the inspector's presence and proximity. The association's prior correspondence was reviewed, confirming the lack of any scheduled inspection or alleged violation. Even the governing bylaws were pulled up and cross-referenced in real time, not as a threat, but as confirmation. The inspection concluded as abruptly as it began. The inspector exited the property with the same confidence she had entered, apparently satisfied that authority alone justified the intrusion. The lawn returned to stillness, but the situation had already moved beyond the physical space. What occurred was not merely a trespass, it was a procedural failure layered atop an institutional habit of ignoring legal boundaries. For many homeowners, such an event would result in frustration, social media complaints, or begrudging compliance with whatever citation followed. This case would unfold differently. Preparation replaced reaction. The incident report was drafted with clarity and restraint, outlining facts rather than feelings. Applicable statutes were cited. Case law regarding private associations and property rights was referenced. The HOA's own documents were quoted verbatim to highlight internal contradictions. By the time the afternoon ended, the situation had transformed from an unauthorized inspection into a comprehensive case study. The association believed it had conducted routine enforcement. In reality, it had created a documented example of rights violations waiting to be addressed. The next step would not involve shouting matches or neighborhood gossip. It would involve formal correspondence, procedural exposure, and an educational reckoning that extended far beyond a single lawn. As the sun set and the neighborhood returned to its curated calm, the foundation for what followed had already been laid, and the HOA had no idea what it had just triggered. The consequences would begin with paper, precision, and patience in the next chapter. The response began not with outrage, but with structure. The unauthorized inspection was treated as an incident requiring formal processing, the same way a constitutional violation would be approached in an academic or legal setting. Emotion was excluded. Precision took its place. A certified letter was drafted and sent to the HOA board. It outlined the timeline of the inspection, the absence of notice, and the lack of consent. It referenced state property statutes governing trespass and the limitations imposed on private associations. It cited the HOA's own bylaws, which restricted inspections to common areas unless specific conditions were met. None had been. The letter did not accuse, it documented. It did not threaten, it clarified. This approach often unsettled organizations accustomed to residents reacting defensively or emotionally. Calm documentation shifted the balance of control. Simultaneously, a public records request was filed with the county to obtain all complaints, inspection logs, and enforcement actions associated with the property. If the HOA believed it was operating within its authority, the records would support that belief. If not, the absence or inconsistency would speak for itself. The HOA responded predictably, though not wisely. An internal notice circulated, attempting to justify the inspection as routine compliance activity. The justification was vague, unsupported, and legally irrelevant. Routine did not override rights. Compliance did not nullify consent. What followed was escalation, but not from the homeowner. A violation notice arrived citing exterior conditions allegedly observed during the inspection. The notice relied entirely on the unauthorized entry. It included photographs taken from angles impossible to achieve without trespass. This single document transformed the situation from a procedural misstep into evidentiary self-incrimination. The violation notice was preserved in its original form. Metadata was extracted. Angles and timestamps were analyzed. Each element reinforced the same conclusion: the HOA had documented its own unlawful conduct. Rather than disputing the alleged violations directly, a second letter was issued. This correspondence rejected the notice in its entirety, not on aesthetic grounds, but on constitutional and statutory ones. Evidence obtained through unlawful entry was inadmissible, whether in court or private enforcement. The letter explained this principle patiently, as if addressing students encountering it for the first time. The HOA's legal counsel became involved shortly thereafter. This involvement was evident not through clarity but through silence, followed by retraction attempts. The violation notice was quietly withdrawn. No apology accompanied the withdrawal. No acknowledgement of wrongdoing appeared. Instead, a new tactic emerged. The HOA attempted to amend its rules, proposing expanded inspection authority under the guise of community standards. The timing was not subtle. The proposal arrived weeks after the incident and applied prospectively, an implicit admission that prior authority had been lacking. The proposed amendment was circulated among homeowners, many of whom had never considered the implications of such language. Inspections sounded benign until framed as warrantless searches. Authority sounded orderly until examined under constitutional scrutiny. An informational memo was distributed explaining the proposed changes in plain terms. It outlined how expanded inspection powers could affect privacy, property values, and legal exposure for the association itself. It cited court decisions where HOAs faced liability for overreach. It did not instruct residents how to vote. It informed them. The community response shifted rapidly. What had once been passive acceptance turned into cautious skepticism. Board meetings grew tense, though still outwardly polite. The inspector who initiated the incident was noticeably absent from subsequent enforcement activities. Behind the scenes, the HOA's counsel advised restraint. Insurance providers requested clarification. Risk assessments were conducted. All of this stemmed from a single unauthorized inspection that had been meticulously documented, rather than emotionally contested. The situation had evolved into a broader lesson about power, procedure, and accountability. The HOA no longer controlled the narrative. The paper trail did. As the association prepared for its annual meeting, the stakes became clear. The inspection was no longer an isolated event. It was the catalyst for systemic review, and the outcome would determine whether the HOA adapted or doubled down. The resolution would arrive not through confrontation, but through consequence in the final chapter.
The annual HOA meeting arrived with an atmosphere markedly different from years past. Attendance was higher. Agendas were longer. Legal counsel sat prominently rather than peripherally. The unauthorized inspection, though never named directly, shaped every discussion. Reports were delivered with careful language. Enforcement procedures were described as undergoing review. Inspection protocols were labeled as temporarily suspended pending clarification. The proposed rule amendment was quietly removed from the agenda, its absence speaking louder than any explanation. What followed was not a dramatic downfall, but a methodical recalibration. The board acknowledged, indirectly, that prior practices had exposed the association to legal risk. New training requirements were introduced for inspectors. Consent protocols were drafted. Notice periods were formalized. None of these changes were framed as responses to a single incident, yet all of them traced back to it. The inspector responsible for the unauthorized entry did not return to her role. Her departure was framed as a personal decision. No announcement accompanied it, no acknowledgement followed. The quietness of the exit underscored the seriousness of the mistake. From the homeowner's perspective, the outcome required no celebration. The objective had never been punishment or humiliation. It had been correction. The HOA had tested the limits of its authority and encountered the boundaries imposed by law. The violation notice remained withdrawn. No further enforcement actions were initiated. The public records request yielded minimal documentation, reinforcing the conclusion that the inspection had been improvised rather than authorized. Months later, the association distributed updated guidelines to all residents. These guidelines emphasized respect for private property, adherence to state law, and the importance of voluntary compliance. The tone had shifted from command to cooperation. The neighborhood returned to its curated calm, but with a subtle difference. Authority now carried an awareness of consequence. Homeowners carried an awareness of rights. The balance, once skewed by assumption, had been corrected by information. The incident became a quiet reference point rather than a public spectacle. Neighbors shared the story cautiously, often expressing surprise that such overreach had been possible. Others expressed relief that someone had addressed it without escalating tensions. For the homeowner, the experience reinforced a professional truth, often taught but rarely lived so personally. Constitutional principles do not reside solely in textbooks or courtrooms. They apply wherever power meets property, wherever authority asserts itself without justification. The HOA had not known the homeowner's profession when the inspection occurred. That ignorance had been incidental. The outcome would have been the same regardless. Rights do not depend on credentials. They depend on willingness to assert them correctly. In the end, the inspection that began as a routine overstep became a masterclass in accountability. The association learned that governance required restraint. The community learned that compliance did not mean surrender. And the lawn, once the site of unauthorized authority, returned to being just a lawn. The story concluded not with confrontation, but with correction, leaving behind a neighborhood subtly transformed by the quiet enforcement of the law.